खरीदी थी, एग्रीमेंट हुआ है और पार्टी अलाउ है माइलट रिफंड के लिए 61,000 जो है हमको रिफंड करने के लिए हुआ है।
क्या चाहते हैं आप? और आपका अपील बार बार लिमिटेशन है?
लिमिटेशन के आधार पर माइलट सूट हमारा डिसमिस हुआ है।
नहीं कुछ आपको बोला पैसा जमा करा दिया आपने?
पैसा नहीं जमा नहीं हुआ है, हमको जमा
नहीं
रिफंड
आपको पैसा मिल गया?
नहीं मिला है।
चल लीजिए आप। पैसा दे दीजिए इनको।
ये लो।
क्या कहना है आपका? Milord, if there is no any illegality in order passed by the क्या है मिस्टर राजपूत? 4 बार बुलाने के बाद आप आए हैं आज। Milord, I am tendering my apology, Milord. First आज पहले so far is legal लिखते हैं। Two point is legal issue also decided against the plaintiff, Milord. And Milord, willing in ready and willingness, Milord, also issues decided against the प्लेंटिफ मिलोट की तैयार रजामंद थे। इनको जानकारी होने के बाद भी इन्होंने कभी रेडी एंड विलनेस नहीं दिखाई मिलोट। इशू नंबर 2 and 3 मिलोट एंड लीगल इशू आल्सो अगेंस्ट मिलोट की इनको नॉलेज होते हुए भी टाइम बार्ड है। कोई दस्तावेजी एंड सो फार इज 61,000 इन कंसर्न मिलोट। इफ नॉट पेड मिलोट वी विल पेड। इंटरेस्ट के साथ पेमेंट कर। आपकी तो अपील नहीं है इसमें। 61,000 वापस कर दीजिए। श्री अनिल सिंह राजपूत फॉर रेस्पोंडेंट नंबर 1, श्री अजीत सिंह फॉर रेस्पोंडेंट नंबर 2। दिस अपील अंडर सेक्शन 96 of the Code of Civil Procedure, comma 1908 for short CPC has been filed, being agreed by the judgment and decree dated 14/9/2012, passed in civil suit number 153/2011, by which the suit for specific performance filed by the appellant is dismissed. However, the Learned Trial Court directed the refund of the advance money of rupees 61,000. Advance नहीं है, the sale consideration of rupees 61,000 within a period of 2 months from the date of judgment, dealing with 6% interest to be paid by the respondent number 1. Full stop. Parties are hereinafter referred to their status in the trial court. Full stop. The नहीं आ रही। देखिए अभी तक आया कि नहीं आया? The admitted fact in this case is that an agreement was executed for by and between the parties. It is also admitted that the notice was issued by the plaintiff and the reply was made by the defendant. And defendant denied to register the sale deed. Stop. Next para.
একদিন আমার ওখানে ছিল
As per pleadings of the, as per pleadings,
সম্ভবত বড় ওই যে অঠানটাই বছর ছিল
an agreement dated 17/6/2005, Exhibit P5 was executed by and between the plaintiff and the defendant. Number 1, the sale of the property comprised in piece of Kasra number 708,710,712 area 30 decimal. Situated at village Chapora, post Chapora, PH number 13, Tehsil and district, Tehsil and police station, Dhasima district, Raipur. Stop. The $87,000 per acre rate was fixed, and 61,000 rupees as total sales consideration was received by the defendant number 1. Stop. Registration of the sale deed was to be done after division of the holding. Stop. It is pleaded by the plaintiff that despite of several requests, the division of the holding from the other holders were not made by the defendant, and by giving a false pretext, the defendant number was avoided to execute the sale deed for execute and register the sale deed. Stop. The division of the holding was not intimated to the plaintiff. Neither any documents were made available to him by the defendant number 1. Stop. The notice was issued by the plaintiff, by the defendant plaintiff, which was replied and denied the registration of, denied the execution of the sale deed and denied the execution of the sale, execution and registration of the sale deed. Stop. The plaintiff was ready and willing to perform the part of the perform his part of the contract dated agreement dated 17/6/2005. Therefore, claiming the above stated relief, the civil suit was filed. Stop. Next para. अभी आ रही है ना आवाज? आ रही है. Defendant filed the written statement and denied the averments of the claim application, and it was pleaded that he has not received the sale consideration, and pleaded that at the time of registration, the payment was to be made. The division of holding was orally intimated to the defendant plaintiff, and the plaintiff was aware of the fact that division of holding has already taken place. Stop. It was further stated that it was further pleaded that the defendant number 1 has executed a sale deed in favor of Om Prakash Mishra, in which the plaintiff has put his signature as witness. Despite of having knowledge prior to 2006, the plaintiff did not
Plaintiff did not demand any document, neither shown any interest in execution, or neither shown any interest in performance of the agreement. The suit was not valued properly, therefore paid for dismissal of the suit. On the basis of above on the basis of above pleadings, the plaintiff, the London trial court framed the following issues. उसमें ऊपर आ गया ना, by third additional district वो लिख देना, और short trial court लिख देना. Page number 9, issues. All the issues. Issue number 1 was issue number 1, 3. One, 3, and 7 was decided as proved, and issue number 2, 4, 5, and 6 was decided as not proved, and in the issue number 8 for relief and cost, the suit of the plaintiff was dismissed, and a refund of rupees 61,000 was directed to be made within a period of 2 months. Else 6% interest would be payable by the independent. Number 1. लिखिए, Shri A.D. Kuldev, Learned Counsel for the petitioner, Learned Counsel for the appellant submits that the London trial court committed an error of law as well as fact in dismissing the suit of the plaintiff. He further submits that the London trial court has not appreciated the evidence brought before it to its proper perspective and erroneously dismissed the suit. He submits that plaintiff was ready and willing to perform his part of contract, and therefore the impugned judgment and decree may be set aside. Opposing the same, London Counsel for the respondent submits that the agreement was executed in the year on 17/6/2015. The civil suit was filed on 9/4/2011 after a lapse of period of limitation. He submits that the division of holding of the suit property was already in the knowledge of the plaintiff. He further submits that the London trial court has meticulously examined the evidence brought before it and passed the impugned judgment and decree, which does not require any interference. Heard the London Counsel for the parties peruse the record. The agreement is executed on 17/6/2005, which is marked as Exhibit P5. As per recital of the agreement, the suit property was agreed to be sold at the rate of 87,000 per acre, out of which 61,000 rupees was received by the, according to which 61,000 was received by the defendant number 1. The recital also envisages that the registry, since the division of the holding has not taken place, the registry could not be done. It would be done after division of the holding takes place. The execution of the agreement has not been disputed by the parties. The London Council framed issue with regard to readiness and willingness as issue number number 2. Plaintiff has pleaded, plaintiff in his evidence before the court try to establish on record that he was ready and willing to execute the sale deed, and the division of holding was not informed to him. In his cross-examination, the plaintiff has stated that he came to know, later on he came to know that the division of holding has already taken place. And the said suit property was sold by the defendant number 1 to one Om Prakash. Is being sold to one Om Prakash. And he is also admitted that he was a witness in the sale deed. He is also admitted that he has not immediately sent the notice after the suit property was sold to one Om Prakash. He stated that he has sent the notice on 17/2/2011. He has admitted that before 17/2/2011, he has not made any written notice. Next para. Defendant number 1 Kamta Pratha was examined and he is denied.
Hello.
That he has received rupees 61,000 at the time of execution of the sale agreement dated 17/6/2005, Exhibit P5. He is deposed that in the year 2006 itself, 2006, he has the division of the holding. He has divided the holdings, and the division of holding was orally informed to the plaintiff and asked him to get the sale deed registered. He further deposed that his name was recorded in the revenue records in the year 2006, and it was in the knowledge of the plaintiff. He further deposed that the plaintiff was a witness in the sale deed executed of this. Plaintiff was the witness in the sale deed of this suit property in favor of the Om Prakash Mishra. Sale deed dated like that, 16/12/2008. He further deposed prior to 17/2/2011, the plaintiff did not make any oral and written effort to get the sale deed executed, as he was not ready and willing to purchase the suit property. He has never shown his readiness and willingness to get the sale deed executed and registered. He stated that the suit of the plaintiff is barred by limitation. The agreement was executed on such and such date, the notice was issued on such and such date, first up. the plaintiff has already admitted that he was supposed to signature as a witness in the sale deed executed in favor of the Om Prakash with regard to the subject property. First up, the sale deed was executed in the year 2008. 2008 first up. The learned trial court meticulously examined the evidence brought on record and decided the issues against the plaintiff. First up, after due scanning of the evidence, this court does not find any error or irregularity. Appeal fails and dismissed. Yes.
God bless you.
হ্যাঁ হ্যাঁ এটা না ওটা